Hello, and welcome to Webinar 5, Accommodations, Risk, and Compliance, created in partnership between Thrive in Your Workplace and the New York Legal Assistance Group. This webinar will primarily provide an overview of the process for considering and providing reasonable accommodations to employees with mental health impairments who require modifications on the job. In addition to giving a comprehensive outline of the legal considerations governing reasonable accommodation requests, one of the primary goals of this presentation is to address and correct a common misconception that employers have that they cannot talk about mental illness in the workplace. To the contrary, it's actually vital for employers to create a culture of acceptance that encourages employees to speak about any mental health issues they may have, and that makes it easy for these employees to find solutions to their struggles. Though the structure of the law means that employers can't presume an individual has a mental health issue by asking, for example, are you depressed? Which we'll go into more detail about later. Employers can discuss mental health in a broad and generalized context, and they can talk to an employee one-on-one about their mental health needs where the employee's already come forward and disclose their condition. So we'll begin first with the legal considerations governing reasonable accommodations. Under the Americans with Disabilities Act, also referred to as the ADA, the New York State Human Rights Law, and the New York City Human Rights Law, employers have an affirmative obligation to provide reasonable accommodations to employees with disabilities, which includes employees with mental health impairments. The legal requirements for providing a reasonable accommodation primarily consist of three sub-considerations. Firstly, whether the accommodation need stems from an actual mental impairment or disability. Secondly, what possible reasonable accommodations exist. And thirdly, whether there has been a good faith interactive process between the employee and the employer to accommodate the employee's disability. So beginning with the first prong then, how do federal, state, and city laws define a disability and what mental health impairments fall under their protection? So the ADA defines a person as disabled if A, he or she suffers from an impairment, and B, if that impairment substantially limits a major life activity, where such activities include, for example, sleeping, learning, concentrating, communicating, and interacting with others. After the 2008 ADA amendments, substantially limits is now construed more broadly. So now it no longer matters if your disabling symptoms come and go. What matters is how limiting they would be when the symptoms are present. And furthermore, how well a person can function in the presence of mitigating factors such as medication is no longer taken into account in determining whether they are disabled. So, for example, an employee who is suffering from anxiety disorder who takes medications that almost wholly eliminates the negative symptoms of the condition would still be considered to have a disability under the ADA, even though the medication reduces the effects of their anxiety. And then under state and city human rights law, substantially limits is not even a factor in the analysis of what counts as a disability, and thus the class of cases covered by these disability laws is even more expansive. State law only requires that an impairment be medically demonstrable, not that it substantially limit a major life activity, and the city law does not require a medical diagnosis at all. In light of these three definitions, what kind of mental health issues might you as an employer encounter in the workplace that would qualify as disabilities under these laws? So any diagnosed conditions such as the major ones listed on this slide, anxiety disorder, bipolar disorder, major depression, post-traumatic stress disorder, and the others here, easily qualifies disabilities under all the relevant laws. They are explicitly listed in the text of the ADA, which has the strictest statutory standards. And then one thing to note is that substance abuse issues, including alcoholism and drug addiction, are protected disabilities under federal, state, and city laws, so long as the person is not currently abusing those substances. The only exception to this is for patients who are certified to use medical marijuana, who are considered disabled under the New York State Human Rights Law. And though coverage under the ADA, the New York State and City Human Rights Laws, is quite broad, the following are some examples of conditions that are not generally considered disabilities. So the first four, compulsive gambling, kleptomania, pyromania, and the current use of illegal drugs, are explicitly mentioned in the ADA as conditions that are not considered disabilities, though the New York State and the New York City human rights laws do not explicitly exclude the first three. They do explicitly exclude the fourth. To the extent that the first three conditions cause the employee to fall short of an employer's objective workplace behavioral standards. So, for example, a kleptomaniac who steals company property, then that employee would no longer be a qualified individual and would no longer be protected by the relevant anti-discrimination laws. And in addition, general psychiatric symptoms that are not the result of an underlying medical impairment are not usually considered disabilities. So, for example, things like poor impulse control, generalized stress, short temper, or difficulty with short-term memory would not be considered disabilities if they are not the result of an underlying impairment, such as bipolar disorder, panic disorder, etc. Since these sorts of symptoms can often be the result of an underlying impairment, the mere presence of one of the symptoms should not make you immediately dismiss the possibility that the employee is suffering from a disability, but you should inquire further to determine whether it does or does not. Ultimately, however, since the laws are quite expansive in their definition of a disability, employers ought not focus too much on determining whether an employee is disabled within the meaning of the statutes, but rather on whether there are any reasonable accommodations that could be provided that would enable the individual to perform their essential duties.
This leads us to the crux of the presentation. What types of reasonable accommodations are the most effective in helping employees suffering from mental health conditions? In order to answer that question, it's crucial to first understand the nature of mental health impairments and specifically the kinds of challenges they present inside the workplace. Mental health impairments most commonly affect executive functioning, which is a set of high-level cognitive abilities, such as the ability to plan, organize, and strategize, pay attention to and remember details, regulate behaviors, manage time effectively, and think abstractly. In addition to setbacks in their executive functioning, individuals suffering from mental health conditions frequently exhibit decreased energy or fatigue, difficulty sleeping, difficulty waking up in the morning or oversleeping, and absenteeism due to illness. Given these unique challenges, employees with mental health conditions require a tailored set of accommodations to properly address these limitations. On this slide, we presented a list of some of the most common and most effective accommodations for employees with mental health conditions. Beginning with the first then, one of the most typical needs for employees experiencing mental health disorders is a flexible or modified schedule, since this can enable them to work optimally during hours of increased attentiveness. Creating a flexible schedule might mean instituting more frequent periods of rest in order to refocus, or having flexible workday start and end times, which can also be very helpful in allowing employees to attend frequent medical appointments or manage the sedative effects of medications often taken in the morning. In a similar vein, allowing an employee to do more work from home can also provide them with schedule flexibility they need to remain productive. Another effective reasonable accommodation could also include providing the employee with a private space to rest, take medication, or perform hygiene-related activities, especially if they suffer from anxiety or panic attacks. Some mental health conditions may have specific environmental triggers that exacerbate symptoms such as noise, clutter, or crowdedness. If triggers are present in the workplace, it can be helpful to identify what they are and modify the work environment to help. Common examples of modifications include allowing an employee to use headphones to listen to calming music, increasing natural lighting, decreasing clutter, or placing them in a quieter or more secluded workplace. For example, we had one client who worked in the stockroom of a Burlington store and who suffered from PTSD and claustrophobia. And by being able to listen to calming music during the workday, the client was able to keep his symptoms in check. Another great tool to help employees whose mental health conditions are affecting their concentration, memory, or time management is modification of instruction and feedback. Written instructions instead of verbal ones, for example, may provide greater clarity, as well as provide the individual's ability to recall details and stay on top of tasks. A reasonable accommodation could also take the form of reallocating marginal or non-essential job functions to other employees. For example, an employee with social anxiety may ask to reassign public speaking or presentation duties to other employees, and doing so could be a reasonable accommodation. Very often, an employee that's suffering from a mental health condition will require time off for treatment and rehabilitation, which is explicitly enumerated as a form of reasonable accommodation under the discrimination laws. This means leave beyond the time granted by the Family Medical Leave Act, which only gives an employee 12 weeks of leave. And lastly, sometimes when no other reasonable accommodations are found that can enable an employee to fulfill his or her essential functions, an employer may consider reassigning the employee to a vacant position that better suits his or her needs. An employer is not obligated to create a new position for the employee, but does have an obligation to consider any vacant positions that the employee is qualified for. With so many types of reasonable accommodations to choose from, do employers have an obligation to choose one kind over another? Though primary consideration ought to be given to employees' choice of reasonable accommodation, the employer can ultimately choose from the different possible reasonable accommodations so long as they're equally effective. There are, of course, limits to the kinds of accommodations that an employer is legally obligated to provide to its disabled employee. Some common defenses that employers can raise to a request for reasonable accommodation include if the accommodation would remove an essential function of the position, if the accommodation would pose an undue burden on the employer, or if the employee poses a direct threat to his own or to others' safety, where such a threat can't be eliminated by any accommodation. In addition, other accommodations that have generally been held to be outside the scope of the employer's obligation include having to pay for or provide the employees with a rehabilitation program, therapy, or personal care assistant, lowering performance of production standards as long as the standards the disabled employee is held to are the same as non-disabled employees. In the following slides, we will elaborate more on the first three defenses, which each require consideration of a very specific set of factors. Where an employer seeks to raise an essential functions defense, an employer must conduct a fact-specific inquiry into the disabled employee's position and investigate how he or she actually performed the job in question in order to ultimately determine whether such a function was really fundamental to their job. Among the factors that can be used to show that a function is essential are if the reason the position exists is in order to perform that function, if the employee spent a considerable amount of time performing that function, or if that function could not really be reallocated to other employees. The mere fact that an employer has a need for that function, that the employee occasionally performed the function while on the job, or that the function is listed in the position's job description does not make it essential, though these factors can contribute to the overall inquiry of whether that function is essential. The undue hardship defense to a reasonable accommodation request basically hinges on how difficult and expensive it would be to provide for a given accommodation. If an accommodation would unduly disrupt other employees' abilities to work and thereby the general operation of the facility, this can be considered an undue hardship. This might happen, for example, if reallocating job responsibilities would prevent other employees from fulfilling their own essential functions. Oftentimes, undue hardship also arises when an employee requests indefinite leave, and this can cause undue hardship on an employer since they can neither permanently fill the position nor plan for the employee's return. Federal, state, and city practice guidelines state that such requests should be evaluated on a case-by-case basis and ought not to be rejected outright just for the lack of a return date. If an employer determines that one particular reasonable accommodation will cause undue hardship, but a second type of reasonable accommodation will be effective and will not cause an undue hardship, then the employer must provide the second accommodation. And as for the third defense, employees with mental health issues can sometimes exhibit angry or violent behavior or express thoughts of harm to self or others, which may pose a direct threat to themselves or to others. And in these cases, if an employer is unable to accommodate the employee in a way that mitigates the threat of harm, the employer may raise a defense of direct threat. Like the other two defenses, employers are obligated to conduct an individualized fact-specific inquiry into the unique circumstances of the employee to determine whether they pose a direct threat. And the employer should not make blanket assumptions about whether a certain mental illness inevitably poses a threat. Factors to consider in making this assessment include the duration of the risk, the nature and severity of the potential harm, the likelihood that the potential harm will occur, and the imminence of the potential harm. Evidence used in making the determination may include information from the individual, including the individual's experience in previous similar situations and the opinions of the individual's doctors or counselors. In addition, the EEOC has emphasized in its interpretive guidance on Title I of the ADA that an employer may not deny employment to an individual with a disability merely because of a slight increased risk. The risk can only be considered when it poses a significant risk. For example, a high probability of the substantial harm, a speculative or remote risk is insufficient.
So far, we have covered two of the main legal requirements governing the accommodation needs of employees with mental health conditions. First, that the employee must suffer from an actual impairment under the law, and secondly, that he or she must be given a reasonable accommodation that will allow them to perform the essential functions of their job, notwithstanding the various types of defenses that employers can make to the reasonableness of a given accommodation. Just providing a disabled employee with an accommodation, however, may not be sufficient for compliance with the laws. The laws also specifically require employers to engage in a good faith interactive process with the employee who is seeking an accommodation that will adequately meet their needs. This is a process which can be conducted orally or in writing and which has to be individualized to the specific employee and his or her specific circumstances. And this requirement basically exists in order to prevent employers from maintaining blanket procedures for general categories of disabilities or accommodation requests. So under these laws, an employer's obligation to initiate a dialogue with an employee is triggered by very specific circumstances. Under federal law, an employer's obligation to engage in this process is triggered once it becomes aware of the employee's disability or need for accommodation. Although generally this means that it's the employee's obligation to request the accommodation and explain that it's the result of a medical condition in cases where the impairment is obvious, like an employee who's suddenly walking around in a boot, the obligation to begin an interactive process can commence without any formal accommodation request by the employee. Under the New York City human rights law's cooperative dialogue requirement, the employer has an even broader obligation to initiate discussion with the employee, since the law explicitly covers both cases where the employer knew of the disability or should have known of the disability. So what this looks like in practice is that if you as an employer observe a sudden drop in performance for a high-achieving employee, or if you have any suspicion that the individual may be struggling with an aspect of the job that could be due to an underlying impairment, then you have an obligation to initiate a dialogue with them. This should look something like approaching them and saying, I see you're struggling. Is there anything we can do to help you? We have XYZ resources for your support, and requests for accommodations can always be directed to us via ABC methods. This dialogue should not take the form of asking the employee if he or she has a disability or assuming that he or she has a disability, since this can be problematic in its own right. Instead, the dialogue has to be confidential while also proactive and basically just open up the door for help without automatically assuming they have any mental issues. In addition, under the New York City human rights law, the employers must provide a written statement at the end of the reasonable accommodation process, outlining all accommodations requested and discussed and whether those requests were granted or denied. Note also that under all of these statutes, an employee is also required to engage in this interactive process, and if he or she fails to cooperate, the employer is no longer liable for failing to provide a reasonable accommodation. One other unique thing about the New York City human rights law is that an employer's failure to engage in the cooperative dialogue is actually its own private right of action, for which employers could be liable for damages, including compensatory damages, punitive damages, and attorneys' fees and costs. The New York City Commission on Human Rights Legal Enforcement Guidance states that when they are considering whether an employer has engaged in good faith with a disabled employee's accommodation request, the commission considers, one, whether the employer has a policy informing employees on how to request accommodations based on a disability, two, whether the employer responded to the request in a timely manner in light of the urgency and reasonableness of the request, and thirdly, whether the employer sought to obstruct or delay the cooperative dialogue or in any way intimidate or deter the individual from requesting the accommodation. So during the interactive process, employers can be entitled to request medical documentation from a treating healthcare provider to confirm the employee's disability or need for an accommodation where the impairment is not obvious. This kind of request can only ask for documentation that is needed to establish that a person has a disability and that this disability necessitates a reasonable accommodation. If an individual has more than one disability, the employer can request information pertaining only to the disability that requires the reasonable accommodation. This requirement also means that in most situations, an employer cannot request a person's complete medical records because it is likely to contain information that's unrelated to the specific disability at issue. Any medical information that is disclosed during the reasonable accommodation process, in addition to any information about the employee's accommodation request and whatever accommodations were granted, is all subject to the confidentiality requirements of the ADA. Confidentiality requires that this information only be shared with staff that are participating in the accommodation determination process or who have to do something differently as a result of the accommodation. And in addition, confidentiality means that any medical information obtained has to be kept in a file separate from the employee's personnel file. A few exceptions to the confidentiality rule includes one, which I've already alluded to, that supervisors and managers may be told about necessary restrictions on the work or duties of the employee and about any necessary accommodation changes. Secondly, first aid and safety personnel may be told if the disability might require emergency treatment. Thirdly, government officials investigating compliance with the ADA can be given relevant information if they request it. And fourth and fifth, employers can disclose confidential medical information to state workers' compensation offices, state second injury funds, or for insurance purposes. So, although this is not formally a part of the law, in order to engage in a cooperative dialogue with an employee suffering from a mental health condition, employers should be aware of the kind of language that's best and most constructive to use versus language which can be dismissive or distressing for an employee to hear. So, though perhaps well-meaning, something like trying to empathize with an employee suffering from a mental health condition by relating it to your own hardships when you have not yourself ever been diagnosed with a mental health condition can actually just serve to minimize the employee's hardships and obstruct the process of working together with them towards a solution. So saying, "I once felt sad when my dog died too," in response to an employee's disclosure that he has major depression only causes more animus and frustration from the employee. And that's an example from one of our actual clients. The same line of reasoning goes for comments like, "just try to stay positive," or "things could be a lot worse." Another common misconception is that the same mental health diagnosis should look the same for all people or ought to somehow be consistent across all functions. So we had one client who suffered from major depression, agoraphobia, and social anxiety. And this client had difficulty conducting in-person trainings due to her anxiety. However, she was comfortable doing webinar trainings. Her employer, however, turned to her and asked her, "If you can give a webinar-based training, why can't you give an in-person one?" Failing to understand the meaningful difference between the two and generally failing to understand that the same disorder or condition can look different for each individual. On the flip side, then, what are some positive ways to engage with an employee suffering from a mental health condition? Your conversation should indicate that you are engaging in a partnership with them and not an adversarial relationship. You should make them feel heard in whatever way you can, and you should make sure to practice compassion and give them the space to verbalize their unique viewpoint. Our clients have also mentioned that it can make an enormous difference when an employer provides them with a bit of positive affirmation. For someone who is already having enormous internal struggles, pointing out when they are excelling or doing something right instead of only focusing on what they're doing wrong can keep them grounded and motivated enough to push through their struggles. Ultimately, for an employee suffering from a mental health condition, their job is perhaps even more important to them than the regular worker because it provides them with stability and a sense of purpose, which they may not be having in other areas of their life. So it's very important to remember this and not necessarily view their shortcomings as intentional or as indications that they don't value their jobs, but rather to try your best to work with them to maximize their potential. And this quote here from one of our clients, I think really encapsulates the importance of proper dialogue and engagement when working to accommodate employees with mental health issues. This client said, "It's so important to feel listened to. My client was the only one at my job who, when I came to talk to her about my struggles, silenced her phone, took out a notepad, and made it clear she was going to do something about it. It made me feel like I mattered. If company management had done the same thing for me, you and I would not be talking right now." Once you do become aware as an employer that your employee is suffering from a mental health illness and the cooperative dialogue or interactive process has begun, it's crucial to check your biases and make sure that you are not treating him or her differently on the basis of any changed perception of their abilities unrelated to their actual functional limitations. Unfortunately, it happens all too often where an employee discloses that he or she is suffering from a mental health condition, and the employer then begins to view and treat them as less capable, weak, or crazy. Under federal, state, and city laws, employers are explicitly prohibited from taking adverse actions against an employee because of their disability, which includes failing to promote them, reducing their hours or responsibilities, assigning them less desirable work, harassing or terminating them.
As a closing thought, here are general practice tips to help employers stay within compliance with the laws and avoid legal problems down the road. Establish a standard procedure for requesting accommodations and ensure all employees are aware of this procedure. Train managers and supervisors on how to engage in a cooperative dialogue and other relevant legal requirements. Document everything and respond to all requests in writing. Explore all possible accommodations, not just the ones requested by the employee. Monitor employees after giving an accommodation to ensure their needs are being met. Prepare accurate, detailed job descriptions that reflect the essential functions of their position. Thanks so much for joining us, and feel free to visit our websites to learn about our respective organizations and get access to more informational webinars.